Good morning, everyone, and welcome to this latest in the series of Mosaic virtual coffee morning recordings. My name is Barry Wilkinson, and with me I have Howard Hackney and Nigel Haddon from our Mosaic team. And we have as our special guest today, Amy Bell of Teal Compliance.
Good morning.
Morning, everybody. Amy is an expert in all things to do with compliance, and I have to say, over the years, she's one of the few compliance experts who I've actually been able to listen to without getting completely baffled by the whole subject. So, Amy, would you like to just do a little bit of an intro so that we can all understand where you come from, which is a bit different to a lot of compliance experts?
Yeah, absolutely. So I'm a solicitor. I was qualified in 1999, so a last century solicitor. I worked in private practice in personal injury, actually, at the beginning of my career. But in 2005, I took an internal move into compliance. I was a legal skills trainer. It was my job to make sure that compliance was accessible, easy to understand. And I was there for, goodness me, 7 years, I think, before I went to join Quality Solicitors, the network, as their head of risk and compliance, which was a really interesting role. I suddenly had lots of clients that came to me for support, and that's where I really got my love of being a consultant, because there were different problems to solve every day, and it just gave me such a lot of visibility, because one of the problems is you only know what you know, don't you? That was a kind of baptism of fire. In 2017, I decided to go out on my own, and the plan was just to be me on my own, actually. I think Barry will remember us having a chat about it.
Yep.
But actually, when we started, we realised there were a lot of firms that needed help. So I'm not quite world domination, but we are trying to help all the law firms that we come across. So we need a big team to do that.
Well, at the moment, I know we're recording this at the time of the Ukraine invasion, and there are all kinds of new things coming over the hill as a result of that, cyber attacks and all the rest of it. Amy, would you just like to sort of give us a little bit of a menu of what you think are the things that managing partners in particular ought to be looking for on the compliance front over the next year or so, if we can look that far ahead?
Well, it's very hard to say where we are recording it now, isn't it? But there are some fundamental things that will come in whether or not there's global issues, but I will touch on those. First of all, I think the direction of travel in how we're regulated is really moved. We obviously probably have all still got the copy of the 1999 Guide to Professional Conduct of Solicitors, which is a great big book full of rules. But over the years, the regulation in the legal sector has moved to something called outcome-focused regulation. So that means instead of telling you a really strict rule, just saying the principles of what you've got to achieve as an output. And that makes it quite hard, actually, because when you've got rules, you know where the line is. When you haven't got rules, you've got to judge. And so we've had outcome-focused regulation for a little while. But what's interesting is before COVID, the SRA, along with many other regulators, issued some further kind of some looser regulation. I mean, I don't mean looser as in you don't have to do it. I just mean as in the words, less rigid. The regulator was finding that they were having lots of people coming to them with innovative models of how to provide legal services. And the rules were still or the guide and the code of conduct was still too prescriptive to allow that. So they kind of watered it down further so that people could achieve these interesting business models. Now, one thing to note about this that I think that we haven't talked about a huge amount because of COVID coming, but the wording in that code of conduct that we now have to follow talks about the firm having to ensure, or the solicitor having to ensure, that something happens. And this is, it's necessary for the regulator. If you take rules away, you definitely have to make sure you're telling people to do something. And the implication of that is if it fails, if there's a breach, then there's the risk that the regulator thinks you haven't insured, and then there's a regulatory obligation for you. So where that takes you to manage that is to be sure it works. And this is a really big development, actually, because when we had rules, you just had to follow the rules. A lot of people have put policies and procedures in place, but they only know if they don't work if they break. They don't necessarily know that they work just because they've tested them. And I think coming on the horizon, the biggest thing that we have to do in compliance is start thinking about how do we test these things? How do we know that they're working? So a really obvious example would be data protection. Now, all law firms say you have to keep clients' information confidential. We all know that. And we all know that there'll be a policy somewhere that says, should you have to destroy confidential information, you use the shred bin. So the confidentiality is the policy and using the shred bin is the procedure. Now, the control of that, what do you think it is? How would you test that that's working?
No idea.
Well, normally I look in the shred bin, you know, there's the special shred bin, but that will only show you who is doing it. If you want to know if people are actually doing it, you've got to look in the normal bin. And that's an example of a control. And so in terms of the kind of global environment that we find ourselves in, anti-money laundering is probably what I'm best known for. I'm a member of the Law Society's Money Laundering Task Force. So I've been working with the Law Society for 12 years on AML. And we have had this period of time where solicitors have been accused, I do use the word accused, I do mean it, I think it unfairly accused of being professional enablers of money laundering. And we even see in this recent times, the concerning the Russian oligarchs and how they've been using their money to buy property in London, the solicitors, the lawyers are really getting criticised about that. I think where this plays out is firms need to be able to demonstrate that they have got effective AML policies and procedures. So controls to make sure that they're being followed, but also that they've really worked out their risk appetite, what people can do, and communicated that properly across the firm. One of the most common bits of feedback that I get from people working in AML compliance is that they get challenges from time to time from the partners within the firm, because they'll have flagged up a risk, or they'll be asking them to do something like get source of funds or source of wealth information, and they sometimes get pushback from the lawyers. I do completely understand that our job is to serve clients, but at the same time, this burden on us of compliance is pretty hefty, and the consequences are just getting more and more severe as regulators are much more likely to take a firm for disciplinary action now. You can see a case of the law firm Child & Child. It was the money laundering reporting officer, in fairness, the lawyer concerned, but he was acting for two sisters who were termed as politically exposed people. Basically, they were the children of a former ruler of a place, and he didn't identify that they were politically exposed people and therefore didn't follow the required procedures as set down by the law. Anyway, the SRA found out about it, took him to the tribunal, and it was, I think, £45,000 fine and £40,000 cost. This is pretty, and no allegations that they were money launderers, just that they were politically exposed people and they hadn't followed the compliance. So,
Amy, can I just come in there in terms of perhaps contrasting my experience being regulated by the Institute of Chartered Accountants and the Law Society. Certainly my perception is the Institute takes a far more practical, realistic approach to compliance issues, anti-money laundering, etc., than the SRA does.
So it's been on an interesting journey, actually, the guidance that we have to follow. But way back when I joined the task force, the Law Society of England and Wales wrote the guidance that the solicitors in England and Wales had to follow. So the regulator didn't write the guidance, it was written by practitioners. And having been part of that process more than once, I can tell you that we've tried as much as possible to maximise the risk-based approach in the guidance to give firms the ability to think about how to deploy these based on risk. What happened after 2017? Well, 2015, actually, there was what's called the first national risk assessment for money laundering. And in that, this is where this phrase professional enabler was coined. One concern in relation to the legal sector and the accountancy sector, in fairness, was that there were many different regulators with slightly different guidance. So they wanted to see one central guidance. So now we have the legal sector affinity group guidance, which is basically all of the representative bodies and all the supervisors together writing the guidance. In the legal sector, what's happened very recently, I'm talking the last 12 months, is that the LSAG is what we call it. The LSAG guidance has been rewritten, fully rewritten, and the majority of the drafting, although it's approved by everybody in the LSAG, the majority of the drafting was written by regulators. And you can see a different tone to the guidance. I think the ambition from the regulators is to give some more structure to what firms might need to do, especially for smaller firms. The problem with that, though, is it can sometimes detract away from the risk-based approach. That because of this, the existence of this organisation you might have heard of, OPBAS, which is the Office for Professional Body Anti-Money Laundering Supervision. They are the oversight of all the regulators. And so, you know, they're wanting to see that the regulators are assisting the regulated profession in compliance. And I just do think that's taking us away from some of the flexibility that we probably had before. And it's only when you try and live with this stuff for a little while do you realise actually it's giving you unintended consequences, just the same way that they have with the standards and regulations and the code of conduct before.
Amy, I loved a few minutes ago your comment about looking in the waste baskets that aren't the shredding baskets. Have you got any other anecdotes like that?
I mean, one of the things that I always say to people is don't put things in policies you know aren't going to actually happen in practice. I mean, certainly don't say somebody needs to check the waste paper bins once a week if you know well no one's going to do it, because you know that's pointless really. But I think that an attempt when you're writing policies to think if somebody was not doing this, how would it show up? Sit in the seat of someone who's trying to break it and figure out how they do it. But when you do see things going wrong with compliance, it's often because somebody's refused to comply rather than accidentally not complied.
That leads us on quite nicely, Amy, saying sitting in the mind of somebody who refuses to comply. One of the things that we said we would do is devote quite a bit of time to the issue of culture and compliance. And so I think this is a convenient point to draw this first coffee break with you to a close, and we'll come back in our next session and focus primarily on the cultural side. If that's